Good morning. Welcome to Fasken's 2022 mining series, our 12th consecutive. I am Frank Mariage. I am a member of Fasken's Global Mining Group and a partner in our Montreal office. Today's session is our final of our 15 sessions and wraps up the Fasken 2022 mining series. Please refer to the slide on your screen for some housekeeping items. We really do hope you will complete the survey. Now I will turn it over to my colleague, Tanneke Heersche, the moderator for the S in ESG, how Europe is leading the way on the shift from soft to hard law session, and who will introduce today's panel. Tanneke, over to you.
Great. Thanks very much, Frank. And hello, everyone. Thank you for joining us this morning or this evening, depending on where you are located globally. Today's session is going to focus on business and human rights as a component of the S in ESG. Just shortly before introducing our panelists, little comment about the extent or the nature of our discussion this morning. I think it's not too strong a statement to state that companies are under increasing pressure to take social and environmental duties seriously. We read regularly in the news about these issues. And for many years, in fact, since 2011, the UN Guiding Principles on Business and Human Rights have provided a framework for companies and states worldwide to frame their activities in this space. And these have been applied and extended across continents and by various stakeholders and participants. Yet for all of their success and their implementation in moving the dial on business and human rights, and despite the increased pressures that many companies are under, we find that many continue to hide behind complex global supply chains, thereby making accountability difficult and providing some scope for avoiding those tricky questions about the impact of an organization's operational footprint. This session today will focus on the next step in the continuum of ensuring that businesses manage and operate their businesses with an emphasis on minimizing their operational footprint in the business and human rights and environmental spaces. The session today will focus specifically on the recent release of the proposed EU Directive on Corporate Sustainability Due Diligence, also sometimes referred to as Due Diligence on Corporate Accountability. The session proves to be, or will prove to be, extremely interesting, and it is very current given that the proposed directive was released only on February 23rd of this year. And although there are parallel legislative processes in this area taking place across Europe, Germany and Netherlands being two examples, the proposed EU directive is seen by many as a turning point in the drive to hold companies accountable. It's the first EU-wide initiative of its kind. And in this sense, and this is part of the reason why we've named our session, Europe taking the lead in the move from soft to hard law. We have, very fortunately today with us, three distinguished panelists with between them a wealth of experience in the international arena of business and human rights. They will assist us in unpacking elements of the proposed directive, discussing the practical implications for companies operating globally, and addressing the state of play in similar legislative initiatives here in North America. I'd like to take a few moments to introduce each of our speakers before we then move into the substantive part of our presentation. Our first speaker will be Francis West. Francis is with Shift, or the Shift Project. He's their business engagement director and has been intimately involved both with the UN Guiding Principles and with Shift's work in the proposed corporate sustainability due diligence directive. So Frances is going to bring us, hopefully, a very inside and insightful assessment of the directive. Brent Wilton, who's a director of Tūhana Business and Human Rights, and is formerly Global Director of Human and Workplace Rights at Coca-Cola Company, will then lead us in a discussion of some of the implications to companies' operations and what corporations and companies can expect to have to implement or address as and when the Sustainability Due Diligence Directive comes into play. Brian Burkett, leading Labor, Employment and Human Rights Counsel at Fasken, is going to then address some of the implications for North American companies, as well as developments here in North America. I think it should be clear from that direction that the international expertise on our panel is significant. And I would like to also just emphasize that the international location of our panelists is appreciated. Brent joins us from Auckland, New Zealand, where it is very early hours. And Frances West joins us from London, UK. So with that, Frances, I'd like to turn it over to you to lead us through analyzing the proposed directive.
Super. Thanks so much, Tanneke, and thanks everyone for your time today. So as Tanneke mentioned, the Corporate Sustainability Due Diligence Directive was released on the 23rd of February. But we've been waiting for this for quite some time. It's been delayed on multiple occasions. So it really is fantastic that we've got this draft or this proposed directive to discuss. And this is really to be seen as the kind of the end of the beginning of this process. There now could be up to 18 months process of debate between the co-regulators in the EU system, the Council and the Parliament over the draft. So it will no doubt undergo some significant changes, but we do have some time to think this through. We've also got quite a bit of work to do, as I will elaborate. So look, we think it's logical to first highlight the objectives of the proposed directive. We think they're very useful when we come to look at whether the specifics of the directive are best designed to actually do what it's intended to accomplish. And our analysis is going to kind of demonstrate that we think that there's a lot more that the directive could do to actually meet these objectives. But there are five main objectives. So the directive aims to improve corporate governance practices to better engage sustainability risk management into corporate strategies. Very important, fully aligned with the guiding principles. Second, there's an objective to avoid fragmentation of due diligence requirements in the single market and create legal certainty for business and other stakeholders. Also something that we agree with and something that many businesses supporting this initiative have been concerned with. Third, increased corporate accountability for adverse impacts and ensuring coherence for companies across EU regulation. Again, important both for business and other stakeholders, including affected stakeholders, as is the fourth objective, to improve access to remedy for those that are harmed. It's very good to see this pulled out as a specific objective now that we're talking about mandatory measures and functions that are the essential role of the state to perform. And finally, to complement more specific EU sustainability measures on topics or sectors. So many of you will be aware that there are a number of other files that are moving around at the EU level, including due diligence in relation to deforestation and in relation to batteries. The Commission also released a statement on decent work alongside this proposed directive, making it clear that it does intend to move forward with an import ban in relation to forced labour. That's going to be a separate proposal. So that's another kind of issue-specific proposal that we'll have to wait for. Now, if we move to the main features of the directive, there are 6 things that the directive does. First, it proposes to establish a duty for companies to undertake sustainability due diligence. And that due diligence should cover actual or potential adverse human rights and environmental impacts. It should cover their own operations, its subsidiaries, and established business relationships. And we're going to come back to that term. Now, it applies to very large and non-EU companies that operate in the very large EU and non-EU companies that operate in the single market. So that is all EU limited liability companies with more than 500 employees and more than 150 million euros in net turnover worldwide. It then applies to a second group of European companies, to limited liability companies operating in defined high impact sectors and that have more than 250 employees and a net turnover of 40 million euros worldwide. Now, those high impact sectors are textiles, agriculture, and the extraction of minerals. Now, it also applies to non-EU companies active in the EU if they have a turnover threshold that's aligned with those very large and large companies, and if that turnover threshold is generated in the EU. So for EU companies, the threshold turnover is worldwide. For non-EU companies, the turnover threshold is in the EU. The third feature is that it provides for enforcement through civil remedies for people that are harmed through a breach of the duty, and also for administrative oversight of compliance with the duty. So that would apply whether or not a harm has occurred. That would rather look at the quality of the due diligence undertaken. And further, it requires companies to establish transition plans to address their climate change risks. That's called out in an individual article separate to the rest of the due diligence duty. And then fifth, it clarifies that existing directors' duties should include taking account of the sustainability impacts of their decisions. A lot of discussion about that before the draft was published. And then finally, it sets out a range of provisions on companies' access to public support and expectations for the Commission to provide a range of guidance and resources. So let's just run through the main features of the due diligence duty. So initially, this is going to look quite familiar to those of you that are familiar with the OECD guidelines and the 6 steps of due diligence set out there. Those of you that are familiar with the guiding principles, this will resonate. First, companies are expected to integrate due diligence into policies, including a standalone due diligence policy. Second, got to identify actual and potential adverse impacts. Third, to prevent and mitigate potential adverse impacts and end and minimize actual impacts. Fourth, establish and maintain a complaints procedure. And fifth, monitor the effectiveness of the due diligence policy and measures. So that's tracking in the guiding principles terminology. And then sixth, to publicly communicate on due diligence. Although if you look at the articles there, it really means report, formally report, rather than a wider notion of communication. So there's a lot that looks familiar there. But also some questions that begin to arise when you start to dig a little deeper. So let's do that. Just to say, we've published at Shift a more lengthy analysis of the due diligence duty component of the directive. And we've got 2 equally strong reactions, really. Firstly, we strongly welcome the proposal. It is a pivotal moment in moving towards markets that require and reward sustainable business practices, as the guiding principles always envisage. We think the Commission's shown leadership on this topic. We think that the objectives of the directive are broadly the right ones. So if framed correctly, this really has the potential to significantly scale better quality due diligence, open up new avenues for remedy, create a level playing field for those already undertaking leading human rights due diligence, and ultimately drive better outcomes for people in the context of business activity. However, we do think that the directive must be more clearly aligned with the international standards of the guiding principles and the OECD guidelines if it's to realise that potential. But also if it's going to avoid fragmentation. This is an EU directive and the UN guiding principles are an international standard. So the directive shouldn't do anything to fragment that international consensus behind the guiding principles. And then thirdly, simply to recognise that we've now had a decade of investment from business and other stakeholders in the implementation of these existing international standards. And we want others to align with that. We don't want this to undermine that. So in our analysis, we see kind of 5 areas where there's a need for greater alignment with international standards. I'm only going to talk through the first 3 today in the interests of time. So the first area is severity. That relates to the scope of the due diligence duty. The second is leverage. That goes to how companies can demonstrate compliance with the duty. And the third is people, the absolutely central role of affected stakeholders in the due diligence process, and how that could be more strongly reflected. So severity. Many of you are going to be familiar with the concept of severity from the guiding principles. It's a key reference point for when companies need to make difficult decisions about where to prioritize. But severity does not feature very strongly in the directive, and let's walk through that. In a good sign, the directive's recitals state that meaningful due diligence should extend to severe impacts throughout the value chain. But when we look at the operative part of the directive, Article 1 limits the scope of due diligence to its own operations, subsidiaries, and established business relationships. And it then goes on to provide a definition of what this concept of established business relationships is. It's defined as lasting relationships based on intensity and duration of the relationship, which are not negligible or a merely ancillary part of the value chain. Now, all of that is new and it's not tested language. So when we saw this, our immediate concern was that really risks creating some perverse incentives. It may well encourage companies to focus on strategic relationships or proximate relationships where leverage already exists, rather than on where the risks to people are most severe. And then secondly, it may well lead to companies restructuring relationships so that companies don't fall into the scope. And these are precisely the reasons that when the guiding principles were drafted, they did not adopt a narrower version of business relationships. They clearly include all businesses in the value chain. And they go on to the concept of severity to help focus and narrow attention and effort. Now, when we look at what's in the draft, we think it's helpful to ask, well, what problems does it think it's trying to solve? And we think it's trying to solve two different problems that perhaps it hasn't arrived at the right answer for doing so. So the first problem is that due diligence needs to be manageable for companies, and we're sympathetic to that. The guiding principles are sympathetic to that. But the guiding principles already provide for this by requiring due diligence across the value chain and then using severity as the basis for prioritization. And the second problem that we think the draft is trying to address, and this is a reasonable thing for it to address, is that civil liability needs to be limited. Now, if companies are going to have civil liability when harm occurs, they're going to need to know what the scope is. But again, we think there's a different answer to that. We think it's possible to separate the scope of liability from the scope of due diligence. But the directive has these two things directly overlapping. You do due diligence just in your established business relationships, and your liability extends to the same scope. And we think that's missing an opportunity. We think there's a real opportunity to use civil liability and administrative supervision as complementary approaches. And that's exactly what the EU Parliament recommended in its report in March last year, which passed with overwhelming support. So what can we do going forward? Well, we think the directive should definitely use existing definitions of business relationships from the international standards for the scope of due diligence. That would align with what many companies have been doing. And second, it should use prioritization on the basis of severity as the organizing logic of due diligence, rather than the novel concept of established business relationships. And that can harness the clear rationale of the international standards of maintaining a focus on where the harm is the greatest. And third, it should distinguish civil liability from administrative supervision, recognize that they have complementary benefits and roles, and take advantage of those. An established business relationship, that might form the basis for liability, but it shouldn't form the basis for the duty to do due diligence because of those perverse incentives and because it's not aligned with the international standards. Now, the second cluster of observations really centers on the way companies have to demonstrate compliance with the duty to do due diligence and how the directive understands that central concept of leverage. Now, demonstrating compliance with that duty for due diligence, that's not an easy challenge. But again, in trying to grapple with that challenge in Articles 7 and 8, we see a real divergence from both the guiding principles and the OECD guidelines in terms of what the expected actions are to prevent and address risks. So those articles have, focus heavily on two problematic concepts. Firstly, the use of contractual assurances by business partners that they will comply with the covered company supplier code or similar policy, and that they will cascade these contractual promises in turn to their own partners. And then secondly, there's strong emphasis on verifying partners' compliance with these requirements, including through third-party audits or industry initiatives, which the Commission may at some point develop fitness criteria for. Now, it could shift, we think this could shift the focus away from all the good work that's been done, looking at the role of purchasing practices, collaboration, etc., in contributing in contributing to risks and how to address them at supplier level. So essentially, we see that focus on the ease of measuring things, the existence of clauses in contracts, the number of corrective action plans, the number of relationships terminated for non-compliance. That's going to drive an over-reliance by covered companies on approaches that have been shown not to be very effective in delivering improved outcomes for people. So we feel there are other overarching features of a company's approach that are also measurable and which shape how it responds to most situations. And one of those features is a company's governance of sustainability risks. Now, the proposed directive does set out the responsibility of directors for overseeing due diligence in Article 26. That includes the expectation that they ensure that the results of due diligence inform the company's strategy. But we do think that the directive could go further in specifying the features of governance that are evidence that a company is more likely to manage its sustainability risks appropriately. So our next cluster of observations relate to the central role of people, to affected stakeholders in due diligence. And as you all know, meaningful engagement with affected stakeholders is absolutely central to making human rights due diligence under the guiding principles effective in practice. It is putting the human into the human rights due diligence. And putting people at the center stage of this process is crucial, as due diligence is fundamentally about assessing risks to people rather than risks to the business. It's not a transactional due diligence process. And the best way to assess those risks is really to ask the people concerned. So, that is not something to be done only where relevant in the opinion of the company, which is what the directive says. So that where relevant may well be interpreted to mean where necessary to a company pursuing a business objective. That might be obtaining a license or a permit, for example. So effective stakeholder engagement is particularly important when assessing risks and when tracking the effectiveness of companies' approaches. And without it, the company is not going to be sure that it's appropriately assessed the severity of impacts to then inform that prioritization of risks, nor can it be sure whether its approaches are actually having their intended effect in practice. Now, our reading of the directive is that this very important role of affected stakeholders in informing that risk assessment is underplayed in Article 6 of the directive. And then when it comes to monitoring in Article 10, affected stakeholders is not mentioned at all. That's a clear gap. Similarly, Article 11 on communicating refers only to formal reporting, not to the broader concept and the guiding principles of communicating with affected stakeholders and others about the company's efforts outside that context of formal reporting. What can we do about this? Well, we'd like to see clearer expectations in those three areas regarding proactive engagement by the companies covered. And the second way in which the draft directive should strengthen a focus on affected stakeholders is in relation to remedy. The term remedy doesn't feature in the draft directive's provisions, and they instead refer to neutralizing the adverse impact. And the draft only gives one example of a way to neutralize an impact, which is through the provision of financial compensation. Now, compensation, that could be a critical component of remedy, but the objective of remedy from a human rights perspective is to put that affected stakeholder, back into the position that they were in before the harm has occurred, or as close to that situation as possible. So it's very likely to involve other steps, such as an apology or support for mental or physical health needs, reinstatement to a position, etc. But that can only really be determined by consulting with the stakeholders themselves. So we think the draft plays into that kind of prevalent perception of remedy as exclusively about finance. It doesn't place emphasis on affected stakeholders' views in remedy, and it certainly doesn't encourage the use of leverage to enable remedy, which is where leading practice has been taking us. So again, what can be done? Well, the understanding of remedy should reflect those many forms of remedy, and it should require companies to consult with those affected on the remedy process and outcome. And we have many more observations beyond these areas and more on these areas themselves. But I think in the interest of time, I'm going to stop there for now.
Great. Francis, thanks so much for that initial dive into the proposed directive. I must say, listening to you, it sounds both very optimistic and positive, and at the same time raises just so many questions. And I must say, if I'm sitting in a position, perhaps Brent, as you were at the helm at Coca-Cola, or perhaps now in advising businesses how they should tackle this, where do you go? You've worked for years with the guiding principles, both within business and advising businesses. You now see this directive, which I think is here to stay, although, as Francis indicates, changes and discussions and negotiations in relation to its final form are definitely still forthcoming. The end of the beginning, Francis, as you indicated, thankfully not the beginning of the end. So, Brent, can you perhaps give us some of your insights and thoughts on the proposed directive and the role it plays also in following on or running in parallel with the guiding principles?
Thanks, Tanneke, and I'd like to also add my welcome to everyone who's joining this webinar, and to thank Francis for a very good run through the main aspects of the draft directive, which I think is important for everybody to start to understand. But I'd also start by saying, don't panic. The extractive industry globally has long had to deal with issues of social expectation and also regulation out of the EU and other bodies. So this isn't something that should come as a big surprise to your industry. You've been in this space before, you'll be in this space again, so don't panic. I think, as Francis said, that there is still time for this to be amended and changed. And so I think it's very important that as business, you remain engaged in the process through your representative structures, that you get involved in the discussions as this moves forward in helping to shape and address some of those issues which Francis has raised. We also have to recognise this is not going to be occurring in a static space. Other things are going to continue to occur. Other states in Europe, including Austria, are looking at legislation. You have the German Supply Chain Act. You have the French due vigilance legislation. The Dutch with their child labour law. You have the UK modern slavery. There are a range of other initiatives that will continue. And you also have going on the side this governmental initiative within the High Commission for Human Rights, which is the draft treaty on business and human rights, which is also subject to lengthy discussion within government circles, with business trying to have a voice on the outside. So there's a lot going on. You'll also see other changes are occurring. We're seeing a greater willingness of courts to increasingly look at giving access to people who have been harmed in jurisdictions outside of the country where the harm occurred. That is likely going to continue. So don't think everything's going to stop while this EU directive is sorted out. I think that's very important. I also think it's not an either or. It's not the EU directive or the UNGPs. The UNGPs, as Francis said, were well developed over many years by the work that Professor John Ruggie brought to this through a lot of consultation with various groups and industries, including yours. And that UNGP framework has now got broad acceptance with many companies around the world. And I think the challenge is going to be overlapping the two, meshing them together in a meaningful way, that you actually sustain the higher standard and not allow a lower standard to dictate your behaviour. But to start with, there's enough now in this draft directive to get you thinking about where it's going to impact you. Do you fall into the definitions of coverage which have been outlined by Francis? What does your supply chain look like, again, from the perspective of who may be impacted by a directive with the groupings that have been identified? How do you go about making sure that if you have SMEs within that value chain that you have to deal with because of the directive, how will you support them? Because there is always a risk, and there has been across the whole supply chain debate for many years. Just shift it down the supply chain. Move the obligations to the lowest level you can, and hopefully shut your eyes and hope that they'll all comply. Well, that's not going to be possible. It's not possible under the UNGPs, and it's not going to be possible here. So the weakest link of your chain needs to be identified and addressed in the way in which you can help them make sure they do the right thing. The other challenge we're having going forward too is this issue of alignment. And I'm very pleased to see that the pressure is still there for alignment with the UNGPs to occur, but also alignment with these national laws that I've talked about. Even the ILO and the Office of the High Commissioner for Human Rights have come out just recently stressing the need to make sure we don't end up, to use Mao's expression, of having 1,000 flowers bloom, because that makes for a very crowded marketplace for any industry or company to navigate. So that alignment piece is going to be very, very important. The other challenge we're going to have too is, and we're beginning to see this in Asia and Africa, Latin America, some of these countries now are beginning to think about a need to do something like the EU directive. Japan is fast-tracking, they say, an HRDD piece of legislation. And Africa, Kenya in particular, is looking at this, because there is a concern growing in some of these more less developed countries in the world that they will be visited upon by the North, and that they will be placed under structures and strictures which benefit the North, not the South. So I think we're going to see some more activity at that level, which we haven't seen before, which is going to further add to the complexity of dealing with things. At the end of the day, many companies, though, are going to look at this and say, let's go for the highest standard and do it everywhere. We've seen that happen with the GDPR, the privacy regulation that came out of the directive from the EU. Many companies around the world adopted that as the highest standard, because in every instance, just about, it sat well above any national legal requirements. And there'll be some of that discussion here now. Is that the best way to do that? Is to stop having all of this uncertainty, just put ourselves at the highest level and move forward from there. Comes with cost, understand that. Comes with challenges, understand that. But you have to think about that against trying to balance competing pieces of legislation around the world and the implications that has on the feasibility of you doing business in some of these countries. So again, think about what's your best standard. Where do you want to sit in this debate? I think something else which is going to be interesting to see too is how we deal with this internally. And that's the internal governance piece. And again, this is already subject to a lot of flux out there. We're seeing a lot more stakeholder interest in the S in ESG. You're seeing more and more shareholder resolutions being equipped to challenge companies on their S in ESG. And companies are not necessarily yet well aligned internally to deal with this. I wrote an article recently on a blog here in New Zealand that talks about ESG as a word, not a set of initials. You can't look at this anymore as silos of environment, of social, of governance. You've got to find a way to bring them together across the organization, within the organization. And that means breaking down those silos and getting people to work together in ways that they haven't worked before to ensure that you as a business are able to integrate these new requirements which are coming through within the business. Because one of the things, as Francis said, is going to be how do you get directors involved in making sure sustainability in its widest sense is part of the decision-making process. How do you prove that? How do you bring that about? And one of the things recently the World Economic Forum came up with was the idea of a chief integrity officer, someone who would sit away from the commercial operations of the business, making sure that the issues inherent in ESG were being adequately addressed in the way in which the company goes about making decisions. We're seeing some of those challenges even today with Ukraine and the challenges companies have working through staying or leaving certain markets as a result of events that are occurring there. The same is going to be with some of the challenges that come through from the due diligence work that is done as you go forward with this legislation as companies in the extractive sector. So this means, I think, more and more, making sure you have cross-functional teams working at the very highest levels of the business, that they have the ability to speak and be heard in the corridors of power in the C-suite, so that those issues are brought to front of mind by a CEO and by the board when they're looking at making business decisions. Because this is always going to be an area of conflict with current business models about improving shareholder return, around doing the right thing. But I think if anyone is looking at the world today, the world is moving towards doing the right thing more than necessarily shareholder value. And that's something that you're going to have to navigate as a business and navigate with your own investors. And then you have the investor community also now wading into this with expectations around sustainability in their investment decisions, in your ratings to get access to finance. We're seeing some of this now coming into free trade agreements and other avenues where human rights and issues of sustainability, climate change and governance are going to continue to emerge. So I think, Tanneke, in summing up, there is a great line from Rowan Atkinson, which is, it certainly is a degree of uncertainty about which we can be certain. But that doesn't mean you need to stop. It means you need to start. You have time. As Francis said, this is 18 months, 2 years away from going through the process. But start now to look at that directive, align yourself internally around how you think you could manage it and what its implications are for your business, and don't panic. Thanks, Tanneke.
Thanks, Brent, for that. And I couldn't agree more from the perspective of the resource industry. The industry has been operating for many, many, many years, addressing these issues, managing these issues. As some have said, to some extent, this is the same wine in a new bottle. Although I think perhaps the stakes have increased. We have seen in various corporates that sustainability teams have been increasingly integrated into the C-suite, as you mentioned, as part and parcel of processes being put in place to address increased stakeholder demands. And this is investors, shareholders, communities, social licenses to operate. So again, these issues are not new. The different avenues that stakeholders have used historically to address some of these issues are also interesting. And Brian, let me turn it over to you to get not only a North American perspective, but also some indication of some of the court processes that Brent mentioned that I believe you were going to touch on. So I'll pass it to you.
Thanks, Tanneke. And to Francis and Brent, thank you very much for all your remarks. That's terrific. As Tanneke indicated, I'm going to focus my remarks on the North American context to the S, the social in ESG, starting with this general comment. I think it is useful as we study this unfolding field that's so important to human development to concentrate on two of the many international instruments. The first is the ILO's Fundamental Declaration, which houses the 4 core labor standards that the global community rallied around in 1998. No child labor, no forced labor, no discrimination in employment or occupation, and freedom of association and the right to effective collective bargaining. The second international instrument that is vital, I think, in this analysis as we move forward is indeed the UN Guiding Principles from 2011. Housed in the UNGP is the language of international discourse over the last decade. And this was written by Professor John Ruggie and his team, now Shift. And so when I'm asked, what is the S in ESG, which seems to be the least understood of the three, the E, the G, and the S, although I'm listening to Brent about how it all has to be integrated, the answer to that is it's pillar 2 in the UN guiding principles. It's business and its duty to respect human rights, or BHR, as it's known by the acronym. And further, when you focus on the UN guiding principles, this second instrument that I think is so important, it's important to remember that from inception, it's been about the creation of a smart mix of measures. And on a quadrant, we're dealing with international developments, we're dealing with domestic developments like legislation, we're dealing with voluntary initiatives and mandatory initiatives. There are your quadrants. I'm going to return to this at the very end. When you move from voluntary to mandatory, that's how you move from soft to hard law, which is in play as we speak. So, North America, what's happening? Unlike Europe, which has relatively equal jurisdictions amongst its 27 member states, North America is different. North America is comprised of a juggernaut, the $23 trillion US economy, and two smaller nations, Canada, a little over 2 trillion, and Mexico at about 1.3 trillion. As a consequence of this reality, developments in North America, including in the social field, are greatly influenced by the United States of America. So we can pick up the thread of current developments in the social field in North America with the recent renegotiation of the NAFTA free trade agreement, which concluded with the passage of what we in Canada call CUSMA, the Canada-US-Mexico agreement, in July of 2020, not that long ago. And this is the place where North America really stepped up, I think, its commitments to both freedom of association and, secondly, the repair of child and forced labor globally. Let me take each of those in turn and note that those come from the Fundamental Declaration. So in terms of trade union rights, what you have in CUSMA are two extensive annexes, one dealing with the reform of Mexican labor laws, and the other dealing with a vehicle that's known as the Rapid Response Labor Mechanism, and these, in fact, are the high watermark of labor rights in any free trade agreement, be it bilateral, regional, or multilateral. The recent secret ballot vote at the General Motors Silao Mexican auto facility, where the incumbent union was displaced by an independent Mexican union, is a clear sign of the changing labor environment as it relates to Mexico. And it, in fact, is hoping to align the Mexican system more with what exists in the United States and the high watermark of Canada. Turning to child and forced labor in CUSMA, this takes us to the labor chapter, which is quite extensive. And I'm going to direct you to a particular article, 23.6, that reads, the parties recognize the goal of eliminating all forms of compulsory labor, including forced or compulsory child labor. Each party shall prohibit the importation of goods produced by forced or compulsory labor. This section in CUSMA has set in motion both customs and legislative reform and measures. Turning first to customs. In the United States, the Customs and Border Protection Services has really focused on the Xinjiang Uyghur Autonomous Region. And under the US Tariff Act, there were 11 withhold release orders in 2021 alone in the United States dealing with goods that valued over $500 million. In Canada, the Canadian Border Services Act, this agency rather, as of July 2020, has prohibited the importation of goods mined, manufactured, or produced by forced labor. And there was one seizure in 2021, the details of which remain confidential. Although the Canadian Border Services Agency is tasked with enforcing import prohibitions in Canada, it's actually Employment and Social Development Canada, ESDC, its labor program, that conducts investigations into suspected forced labor. And currently, as we speak, ESDC and CBSA are collaborating around the Canadian position moving forward. In terms of legislation, moving away from customs, I think there are basically two, and as I've listened to Francis and Brent, there's two basic types of domestic legislation in this arena. One is what we'll call disclosure laws. The focus is on transparency in the operations of the company by requiring periodic reporting obligations. The California statute from 2012, the UK Modern Slavery Act, these would be examples. The second is what we call mandatory human rights due diligence legislation. And this type of legislation imposes due diligence obligations on companies within scope. And so the German Supply Chain Act, the EU directive, and the legislation it's envisaging, these would be examples of mandatory human rights due diligence. So where are we in North America? A little different, not yet defined, I don't think all that well, but starting with the United States, in December of 2021, the US passed the Uyghur Forced Labor Prevention Act, which bars the importation into the United States of products made from forced labor in the Xinjiang region in China. This has never been done before, where you identify a geographic area. And that's the source of the legislation. So under this legislation, which is somewhat pioneering, there's a presumption that products from Xinjiang are made with forced labor. And this presumption is rebuttable and can be overcome if a company importing the goods can prove by clear and convincing evidence that it has followed the guidance to importers. If you turn to Canada, I think the starting point briefly is a statement from the Prime Minister where he's on record that the Liberal government plans to introduce legislation in the House of Commons, quote, to eradicate forced labor from the Canadian supply chains and ensure Canadian businesses that operate abroad are not contributing to human rights abuses. Although the above quote seems focused, actual government measures and initiatives seem less than razor sharp in Canada. So what do we have? Well, we have CORE, the Canadian Ombudsperson for Responsible Enterprise, slow to engage since its creation in 2018, although CORE in 2022 has undertaken a study of the human rights footprint of Canadian companies in the garment sector in relation to child labor. Secondly, customs. I've reviewed that. ESDC and the customs authorities are working together. And then you have draft legislation that is working its way through the Canadian parliamentary system. And there are 3 bills, 2 of them out of the Senate, the most recent out of the House of Commons, 2 of them near the developments that I discussed in terms of the United States and identifying a geographic area. The third, the one that's progressed the furthest, is actually not like the EU Directive and the German Supply Chain Act, but rather more like the UK Modern Slavery Act or the Australian example. It has received second reading and is now in committee. And it is that type of legislation that is under consideration out of the Senate. I'll leave it there for now. That's a lot about Pillar 1 of the UNGP, which is government's activity in this field. Let me quickly and briefly talk about Pillar 3, as Tanneke said that I would, which is about access to remedy, both judicial and non-judicial. So in terms of the Canadian courts, I would make this initial comment. The Supreme Court of Canada, perhaps unlike its US counterpart, it really draws its inspiration from international sources. It has done this, for example, in terms of how it defined labor rights under our Canadian Charter. And in terms of the social field, you know, we have the Nevson Supreme Court of Canada decision from about a year ago, February 28, 2020, where the Canadian court said that customary international law is automatically incorporated into Canadian law, and that customary international law violations are civilly actionable in Canadian courts. Our Supreme Court went a little further and said that violations of customary international law may require, quote, stronger responses than typical tort cases, negligence, duty of care, to take into account the serious nature of the acts involved. And when they said serious nature, the court was referring to forced labor, slavery, cruelty, inhuman and degrading treatment, and crimes against humanity. That's the judicial level. In terms of the non-judicial level, let me simply say that perhaps a little below the waterline, there has been a flurry of activity by civil society to try and design grievance mechanisms, mediation and arbitration systems that can air grievances around human rights complaints wherever they may arrive. Tanneke, in the interest of time, I'm going to just leave it with this one thought. As I listen to Francis and as I listen to Brent, I want to go back to that quadrant: international, domestic or regional when you're dealing with the EU, voluntary and mandatory. It seems to me that what we're witnessing today and what is central to this panel, the S and ESG, is that there is a tremendous amount of activity right now within this quadrant on the domestic or regional, if you're dealing with the EU, and the mandatory quadrants. And that's in the form of mandatory human rights legislation. And that the tension, the active debate that's unfolding, which Francis so well summarized, is as legislators, and drafting is a difficult exercise, as we all know, as they try and pour international standards that have emerged into the drafting exercise, in other words, the mandatory legislation, there's some tension around whether or not there's been alignment between these international standards that are a fairly recent invention, like the OECD guidelines or the UN guiding principles, tension between whether or not there's alignment between those international standards and the legislation that's emerging. My final comment is this: don't forget, for those in North America, that in the original NAFTA, there were no international standards. That was just 1994. The Fundamental Declaration didn't come into existence until 1998 to start this process. This has been a recent development, and it's now really moved into, on the quadrant, the area of domestic or regional and mandatory as we move from soft to hard law. This is the big debate today. Thank you, Tanneke. And thank you, Francis and Brent.
Super. Thanks, Brian, for those comments and for integrating them also with Brent and Francis's comments and material. There's quite a lot here to take in. We've got numerous questions from the audience, and I'd like to try and address as many as possible and maybe try and put them into buckets that relate to each other. One of the first, and Brian, as you said, as we move from soft to hard law, of course, immediately questions as to what does this mean? What does that mean arise? And Francis alluded to some of those definitional issues within his presentation. Brent alluded to integrating, social, human rights, and environmental considerations into one ESG as a word instead of letters. We've had a question as to, what does adverse mean? Adverse to whom? Adverse to what? And another element, I think, there, and Francis, I've sort of picked this up out of your presentation, this concept of, where is the harm the greatest, and the severity and the prioritization issue. How does one go about evaluating that? How, to take Brent's view, how would a chief integrity officer, go about looking at some of this terminology, evaluating whether the harm is greater in one area or the other? What do these terms mean? I know there's no immediate answer to what do these terms mean, but I'd be interested in some of your thoughts, how you see this unfolding, how these terms will be defined going forward. Maybe Francis, I'll ask for your comment first, and then Brent, your thoughts off the back of that.
Well, thanks, Tanneke. So, I think in terms of adverse, what's an adverse impact? Well, it's an adverse impact on, an individual, an impact that prevents them from or obstructs their enjoyment of the internationally defined human rights. The directive, or the proposed directive, sets out the specific human rights that we're talking about. So, that is there. I think there are also a list of environmental standards as well. I'm not an expert on the environmental side, so I won't comment any further on that. In terms of severity, well, the definitions within the kind of international standards will focus in on scale, scope, and remediability. Essentially, the scale of the impact. How grave is it on a particular person's ability to enjoy their international human rights? The scope, so how many people are affected, and remediability, how hard is it to put right? And that is always going to be a relative assessment. There is. I think it's difficult to think of these things in absolute terms. I think what people are looking for is, do you have a robust process, and can you stand behind your prioritization process using that lens? So scale, scope, and remediability, rather than saying this is most important to the business, so we're going to deal with it.
Brent, do you have some comment?
Yeah, just to add, and I agree with everything Francis said. One of the things, of course, it's important for companies to be doing is their human rights due diligence to identify what are those salient human rights risks that Francis is talking about. And if you do your due diligence properly, you'll come up with quite a list of issues that stakeholders and others within the business, etc., have identified as being salient. That then gives you a sense to then apply that test that Francis just elaborated, so that you actually start to prioritize around those key issues. But it's always important, and just to stress again what Francis said, this is about the impact on a person, not the impact on the business. Could be a community, but it's the human element you can't forget.
Tanneke,
And just, yeah.
Tanneke, this is like a vital point, right? As legislation is being drafted, one of the big issues is are the legislatures capturing mandatory human rights due diligence as it's understood in terms of international standards? So Francis said a lot when he said, look, this isn't about risk to the business, it's risk to people. That needs to be underscored. And so John Ruggie wrote about this a lot, talked about it a lot. He said, and he used the example of, this isn't, for example, it's not a transactional risk. It's not, for example, if you're buying land, trying to figure out if you got proper title. Rather, it's early engagement with stakeholders. If, for example, you're a mine and you're involved with a community, it's outreach to that community to try and figure out what risks there may be to the people as a result of the corporation's footprint within that community. Thanks, Tanneke.
No, thank you all. I have to admit, I find this area fascinating, and I find the potential for at some level conflicting interests also of interest. Environmental harm, of course, has an impact on people. How does one contrast that with human rights, direct human rights impact? And from a governance point of view, if you're in the C-suite and your operations have impacts in both areas, how does one start integrating the issues and the concerns as they arise? So I just think this is extremely interesting, and also at some level quite difficult, because, as Francis said, it's relative. They're relative assessments, and at some level there are going to be value judgments that need to be made. We have part of the legislative process is obviously domestic laws being put in place, and Brian, you mentioned. And Brent also covered some of the child labor legislation, for example. We've got two questions from the audience. They're slightly different. I'd like to focus on sort of the role of national governments first. And there's been a question in a comment that, of course, the principles apply to both states and businesses, and states and governments have acted to promulgate legislation to protect human rights. And so where or why now the necessity to come in and, Brent, consult, advise, do impact assessments? How do the two interact? And maybe you could comment on that. And Brian, Francis, I'll let Brent lead on this and see if you have any comment there as well.
Yeah, thanks, Tanneke. It's a good question, because, of course, you're right. Governments have a responsibility to put in place national laws and to enforce them. The trouble is that what they say and what they do can be very different things. Having spent 16 years representing business within the International Labour Organization, I look every year at the Application of Standards Committee report of some 800 pages that talks about failures of government for over 50 years to actually give effect to standards that they have ratified. So it's not about taking people at their word, but it's not about accusing anyone either. What you're doing is you're going in and you're assessing in a human rights perspective using the frameworks of the UNGPs at the moment, but other legislation that may apply, as to whether or not it's a good business decision for you to engage in that activity in that country. And it may well be that there are a variety of reasons that come to the fore which may decide you to do it or may decide you not to do it. But I don't think it's a matter about being offensive to the government. If you go in there and start saying, we'd love to come, but you've got no rule of law, then they're going to get upset, and you wouldn't do that. But you'd go in and you'd do that assessment, and then you'd reflect within the business as to whether or not you believe the circumstances on the ground are sufficient to give you confidence that the rule of law does exist, that the laws that are in place are applied, and that you can have some confidence that you will be acting on a level playing field. Unfortunately, in too many instances around the world, that is not the case. And law is not well enforced, and law is not given the sort of judicial support it needs to function properly. And that's why you need to do these, I prefer to call them human rights due diligence exercises, in order to make sure that you are picking up stones and looking underneath and seeing if there's anything there that could be detrimental to your company's ability to operate properly in any given territory.
Francis, I see you're ready to jump in. Is some comment?
Yeah, no, that's a agree very strongly with everything Brent said out there. I a slightly different tack. I do think one of the gaps in the EU's process has been until now a really not sufficient consultation with both civil society organizations and businesses from outside the EU, which are going to be on the on the receiving end of this directive, essentially. So we need to find ways that both civil society voices and business can represent their perspectives, making sure that we don't end up with what Brent kind of talked about earlier as kind of just this cascading that forces all of the responsibility to the bottom of the supply chain, essentially, which won't necessarily drive the kind of the outcomes for those people that are working in the supply chains in these contexts. So there does need to be some space opening up for them to feed into this process.
So just backing off of that comment, Francis, and Brian, you also had focused on some of the child labor and forced labor laws and regulations. What about the interaction of the regulations and the laws being put in place, but the fact or the question whether or not that actually goes to addressing some of the questions on the ground. So we've had a question from the audience. How does stringent application of these kinds of legislations, child labor, forced labor, help support, and in this example, it's child miners of cobalt in DRC to find alternate livelihoods. So really the question, around the role of legislation versus a more developmental approach. And Francis, maybe you want to comment on that?
Yeah, I just don't think these two things are juxtaposed in the way that the question has done it. So I appreciate where you're coming from. It's really around the framing of the regulation and how you understand due diligence. Now, if you align with the guiding principles and the conception of due diligence within the directive is about making sure that you are using leverage in really creative ways, providing expertise to business partners, looking at the root cause of the problem, bringing in, other parties, advocating towards, governments in some instances to improve standards there on some of these issues. Then I think you can get to some of those developmental issues that you're highlighting that are, absolutely the right approach. I think if you take the current kind of conception of due diligence, which is very focused, current conception within the directive, which, as I've already said, we think needs to change, that's very focused on this contractual assurances and cascading of that down the supply chain. I think it might well lead to a kind of a policing approach that doesn't get to this sort of creative exercise and leverage that you're talking about. So I really think it comes down to, what's what the definition and guidance around this looks like, because it's not the intention of the guiding principles to say you have a harm and therefore you need to cut relationship with a supplier. It's about engaging and trying to change behavior and practice over a longer period of time.
And Brian, do you have a comment on this from sort of the labor perspective or the labor regulatory perspective?
Sure, Tanneke. I mean, I think we're picking up on a bit of a theme here. When we talk about human rights due diligence, we talk about it in terms of outreach to stakeholders, like involving others. Similarly, when we talk about legislation, the governments need to do outreach to make sure that the legislation is as effective and as understandable as possible. And so, for example, in the free trade arena, what we see in Canada is dealing with the provisional trade agreement between the EU and Canada. There's quite an elaborate domestic advisory group, both EU and Canada, that's been created so the government can hear from NGOs and trade unions and employers about how to structure and interpret the free trade agreement. We saw this in the CUSMA negotiations as well. So a lot of talk here about outreach, whether it's a corporation trying to comply with the concepts in the UNGP, to outreach to the people constituencies it's involved with, be they employees or supply chains or communities, whatever, and that governments need to do the same thing as they set about to enter into free trade agreements or to draft legislation. I just want to make one other comment, Tanneke, because I think this is an interesting development tied to this point. And it involves the American Bar Association and its business law section, which is an impressive section within an impressive organization. And within that business law section, they've been trying to draft contractual arrangements between lead companies and their suppliers, contractors, producers, and developers. The first go-round, it was really all in favor of the lead company. It was about representations and warranties that had to be met, only to realize by the business law section that actually you need to go further. You've got to help, as a lead company, your suppliers and contractors to understand and to carry out the sort of human rights achievements that the lead company is trying to achieve. So you can see this evolution unfolding where, yes, we're doing more and more outreach and we're collaborating around that outreach. The ABA story is a case in point.
Thanks, Brian. And just to take your ABA story, also, recognizing the amount of work that's being done by the number of organizations in this space, it really is astounding. I know that we're running on time, but there's one other area or a question that I think would be
Tanneke, can I just add something to that last question, if I may? Because this is something that I faced on a daily basis when I was at Coca-Cola, and this is a very good example of that. And I agree with what Francis and both Brian have said. It's very important here, when you're looking at these sorts of situations, to take a landscape approach to the problem, not a silo approach. So if you're looking at the issue of child miners and cobalt in the DRC, you need to be looking at child labour in the DRC as the issue. Because if you just take a silo approach and remove those children from cobalt in the DRC, they'll go mine something else in the DRC or end up as street urchins in the DRC. So these sorts of issues require multi-stakeholder engagement over very long periods of time in order to try and move the needle on this. You've seen it with the cocoa initiatives in Côte d'Ivoire and the amount of effort and money that has been spent to try and address the issue of child labour in the cocoa farms in that area. So these things don't happen overnight, but if you look at it as a silo, all you're going to do is move the problem to somebody else. And that kid isn't going to get an education. That kid's not going to be able to have a life in the future. So just to be very clear, you need to make sure you bring all sorts of people to the table for an issue like this.
Yeah, and I think, Brent, to follow up on that, all sorts of people to the table and all sorts of initiatives to try and address the problem. So I think, for example, of some of the blockchain transparency initiatives on provenance of minerals, also ultimately directed at ensuring that the provenance does not involve child labor. And it's yet another, different angle on the same issue. So I do think it's important to look at all avenues available to address some of these very core human rights issues. I would appreciate and I do understand that this is a tricky area, but I've been listening and I'm hearing about governance and the boardroom, and I'm hearing about impact on the individual on the ground. And obviously we know that there is a huge chain between that individual and that boardroom. I'm interested, and Brent, you mentioned, some of the court cases that have been ongoing and civil remedies that are available. I think we're all aware of some of those cases that have been making their way through the courts. Similarly, we've had company corporate liability cases that are in the courts. And my question really is one of tension between sort of global oversight of these issues and these operations and the impact that they have on individuals, and the parent company liability sort of issues that are arising or cases that are developing. And I'm just wondering if any or all of you could comment on that tension and how you see that unfolding as these different avenues progress. And maybe, Brent, maybe we'll start with you on this.
Yeah, and you're right, it is a tension, but it's also a big problem of education internally within the business. You have to start people to understand that dealing with risk is inherent and you're looking at human rights, that there is always risk involved there, and risk has to be dealt with. And it comes down to being proactive. It's about making sure you fix issues before they become problems. If anything's going to litigation, it means something's got out of control. Something has not been resolved at an earlier stage for whatever reason. So I think it is very, very important when the board is looking at these issues to always be thinking about how can we make sure that we are proactively engaged with our stakeholders, with our suppliers, with our business partners in education, training, and support. The points you made earlier, very, very important with regards to how that works out. The other thing is you need some critical friends. You need some people out there who don't necessarily like you, but who are prepared to work with you. And again, this is something I did at Coca-Cola quite freely, and I learned from Ed Potter, my predecessor, on this. Where making statements against interest was something he used to enjoy doing on a daily basis. And that's when people said to me, do you have child labour? My answer was yes. It was inevitable. I mean, we were sourcing from over 5 million farms around the world, in India and Africa and all sorts of places. And my answer to those critics was always, yes, we have a problem. Are you prepared to help me fix it? If not, you're just going to throw a stone. I'm not interested. We are trying to work on it. So it's that point of making sure that you do engage with your critics. You get some critical friends who will tell you what's going on, because you need that radar out there to be able to catch all the issues that are coming at you. But I believe very clearly that if you have the right conduits into the board and into the chief executive, and I was very fortunate, I had both, you are able to make things happen very quickly. If it is kept separate and it's not integrated into the business, and human rights or sustainability is an add-on like CSR was considered to be for years, then you will struggle. It's that integration which is key to handling these very complex challenges that can arise like that. I used to say to the board at board meetings, I am one cell phone photo away from disaster for every second of every minute of every hour of every day. That's what it takes. Someone takes a photo of our brand, then Coca-Cola brand, in a derogatory way, we got a problem. And that's the reality. You have to be able to have your radar up, operating all the time, and making sure you're bringing that information into the business.
I think you're probably, Brent, not the only one that has been in that situation of being one cell phone photo away. And it's a fair comment. Francis, has this tension come about at all in the? I'm sure it has, but your thoughts on this tension as the EU process sort of unfolds?
I mean, I'd just say, I think just in relation to some of the existing kind of parent liability cases in the UK that have predated this EU initiative, I think actually quite a lot of the legal opinion was, the appropriate response is not to button down the hatches, but to do exactly what Brent is saying, and to enhance your due diligence. I also, not being a lawyer, so I'm not always looking at that particular angle. But I guess I would say even if you could manage to close off a legal risk by withdrawing, I guess, and not engaging externally, etc., and not doing your due diligence, I think you're likely to end up with a whole host of other risks as a result, in terms of stakeholders and reputation and investors, etc. So, I just don't see that approach as a credible avenue.
Absolutely fair. But Brian, any other thoughts on this?
I thought, especially Brent's comments were very powerful about his experiences at Coke, and would be shared with a lot of the people in the audience. I will only add, not to detract from what's been said, that, the questions start off about court cases. Yeah, there is a judicial side to advancing human rights within the global economy, but don't forget about the non-judicial. Brent talked about finding solutions that include engagement with critics. A big element of that is grievance mechanisms, mediation and arbitration. That's how you do it. And for Canadians, we are steeped in activities by neutrals. We have a rich array of a neutral community. Neutral, I mean arbitrators, facilitators, mediators in Canada. We're very good at this. We rely on it, and we could see more of this globally.
I think that's Brian, a good way. The grievance mechanisms, the other, the range of alternatives and tools that are out there, and I'll tie that back to the proposed EU directive being part of that toolkit in advancing how you deal with risk. Brent, to go to your point, you have to deal with it. Let's deal with it, and let's deal with it in a way that minimizes the operational footprint in a harmful way.
And Tanneke, again, just sorry to interrupt. You want to limit the harm, so you need to work quickly. If you let it grow and become really obnoxious, then the harm is going to get bigger and larger and more difficult to solve. So being proactive early and stopping something from happening even better But getting in with a problem and getting it fixed as quickly as possible is the best thing you can do. It's always cheaper than paying the costs of litigation, reputational risk, brand damage, or whatever.
And it's the right thing to do, to use the phrase that we used earlier in the presentation. I think with that, and given that we're coming up to 9:30, we will close our session. And I'd like to thank each of our panelists very much. These debates and these discussions, these issues will be with us for a long time still. They're fascinating, they're interesting, they're necessary. I thank you all for your insights and for your time. I thank everyone in the audience for joining us today for this discussion, and we'll be watching with interest as the EU directive makes its way through a very complex system, I think. As Frank mentioned at the beginning, this is the last of Fasken's 2022 PDAC webinar series. We hope you've enjoyed them. The recordings are available on Fasken's YouTube page. And of course, as most of you in the audience will know, PDAC will be taking place live, we hope, in June, Toronto, June 13th to 15th. It is in any event nicer to be in Toronto in June than in March. So hopefully we'll see some of you in person during PDAC. Fasken will also be doing some additional seminars, and I'm calling them seminars as we're hoping they will be live during that time. So thanks again for joining us. Thank you, Brent, Brian, and Francis, for a most engaging discussion, and enjoy the rest of your day, everyone.